Very good evening and welcome. You're watching Beyond the Headline with me, Tamanna Inamdar. We're going to talk about a very crucial judgment today by the Supreme Court of India that will directly impact the lives of many, many Indians. We know India has one of the lowest divorce rates in the world, but it is a number that is increasing rapidly. And the legal process of getting a divorce sometimes is very onerous and takes very, very long. Now, after listening to a special petition and getting 4 top lawyers to weigh in on it, the Supreme Court today has carved out a kind of a fast-track divorce for couples in specific conditions. Now, what are these conditions? And why is this judgment important? I'm going to be speaking with Indira Jaisingh, amicus curiae, that means friends of court. She was called upon also to weigh in on this, and she's a top lawyer. All of that coming up, but first, let me take you through what's trending tonight. Supreme intervention in broken marriages, fast-track justice with guardrails on. The top court rules it has special powers to dissolve a marriage that is beyond repair. Centre informs the Supreme Court that it has begun the process to re-examine the archaic and controversial sedition law. Attorney General says matter likely to be taken up in the monsoon session of Parliament. Your safety, our focus. Mirror Now's special campaign on roads continues. We aim to push authorities to ensure rogue bikers follow the rules. In the latest shocker, a biker is booked for killing a florist. They are 2 of the top cities in India, but a small rain spell has brought them to their knees. Instances of waterlogging reported from both Delhi and Bengaluru after a brief downpour. Weather body predicts a 3-day spell of rain for the capital. GST collections rise 12% to 1.87 lakh crore rupees in the month of April. It's the highest ever collection in a single month. Major U.S. lender First Republic shuts down. It's the 3rd major U.S. bank to fail in less than 2 months. JP Morgan to buy embattled bank's assets. India boasts of one of the lowest rates of divorce in the world, just about 1.1%. But is that because Indian couples are just happier in their marriages? Is it because of social taboos still connected with divorce? Or is it also because of the legal complications in getting a divorce when things are just not working out? A landmark judgment of the Supreme Court today has given a way out for couples whose marriages just can't be fixed by ruling that in certain cases, the mandatory 6-month cooling-off period can be waived. So the 6-month period is a law under Section 13B of the Hindu Marriage Act that says that after a couple has lived apart for a year, another 6 months should be given for them to possibly reconcile and save that marriage. Now, the Supreme Court today observed that in some cases where the marriage is irretrievably broken down, that means it just can't be fixed, this 6 months simply extends the agony of that couple. Now, in legal terms, this is very, very important because so far, irretrievable breakdown of marriage is not a recognized grounds for divorce. In fact, it still isn't in the law. But the Supreme Court, using its special powers in the Constitution, has added this ground in certain cases where couples can plead to waive off those additional 6 months. Now, this has already been happening in lower courts in bits and pieces. Petitions were filed in the Supreme Court asking that a uniform direction should be given for all courts to do this. The court then called upon 4 senior lawyers who gave their suggestions. One of them, Indira Jaisingh, will be speaking with us today on why this is a landmark judgment. So why does this matter and what are the conditions? Well, this matters because even though India has low divorce rates, they have been going up consistently. The legal process can get quite tedious, and while 6 months is supposed to be the minimum wait time, The process can sometimes stretch on for years. But this fast-track divorce is not for everyone. There are 3 specific conditions. 1, that the couple should have already been living separately for 18 months before the first motion is filed. 2, that all efforts for mediation and reconciliation should have been exhausted. And 3, differences should have been settled over issues like alimony and custody of children. And after all this, the Supreme Court will use its own discretion to decide whether a couple should have a fast-tracked divorce. So is this really a game changer? To speak on this, I'm joined now by senior advocate Indira Jaisingh. Thank you so much, Ms. Jaisingh, for speaking with us today on the show and joining us on a case in which you have had a very, very important role. Let me begin by asking, how significant is this order that will effectively shorten the time for divorcees in certain cases? Why is this important?
No, irretrievable breakdown of marriage is not a ground for divorce in our laws, which is why it was necessary for the Supreme Court to come in. As I said, is to deal with the issue of what we've been calling limping marriages, which means it's neither a marriage nor a non-marriage. It means that both of them have reached a stage where it's just impossible to get back and to cohabit together as people normally cohabit in a marriage. What does one do in a situation like that? And what happens in a situation like that if one person opposes the divorce? The court then steps in and says it's in public interest to put an end to this marriage. It's a question of changing public policy, looking at public policy differently.
In terms of a process, what changes? Does this mean that people can approach the Supreme Court if they want a divorce under this ground? And will this not add to the huge backlog of cases in the top court?
Look, there's a lot of disinformation on this. Nobody can approach the Supreme Court directly for a divorce. They've made it very clear that no one can approach the Supreme Court under Article 32 directly. A divorce proceeding has to begin in a family court, which is at the lowest level. And it's only when an appeal comes before the Supreme Court and they, having regard to the amount of time that has gone by and having regard to the fact that they come to the conclusion that there is no way in which the two people can at all get together, then the Supreme Court, in exercise of an extraordinary power to what they call to do complete justice, they can come to the conclusion that this marriage has broken down in a manner that it cannot be put together, and therefore they can say, all right, this marriage is dissolved. In the process, while doing so, they've made it very clear that they need to be satisfied that adequate provisions have been made in relation to alimony, maintenance, and custody of the children.
Now, just a bigger picture here, and it's something that you have talked about also, you've posted on Twitter, in fact, saying that the Supreme Court is right now engaged in hearing 3 crucial cases pertaining to the marital life of Indians. One is marital rape, same-sex marriages, and now divorce. This has all caused a lot of debate. Do you think this is a turning point as far as personal relationships go in our country?
Well, in my mind, the 3 are linked together, to be upfront about it. And the one common connecting issue between them is what exactly is the concept of marriage at the end of the day? What is it all about? It's all very well to give it a name, marriage, okay? But what is it about? And the entire argument is that marriage is about a partnership of equals. There has to be sharing, there has to be caring, there has to be affection. It's not just an institution which is economic in nature. It's not just any other institution which is what they commonly refer to as a sacrament. No, it's an institution in which there is sharing, there is caring, there is love and affection exchange between the two parties. That's what makes it a marriage. And when that is gone, then you are left to deal only with the economic consequences of the breakdown. So the law can address the consequences. It can't address the core of what is a marriage. And it's the same issue in marital rape. If you're going to say that a husband has a right to rape his wife. Where is the question of equality in marriage? It's the same issue with same sex. If you say that two people who really care for each other and who really are devoted to each other and who decided they're going to share their life with each other, if they cannot have the status of a marriage, then what is marriage all about? So I think the question arises in all three cases. So it is significant, and that's the reason why I tweeted what I did.
It's also something, Ms. Jaisingh, which raises the hackles of a lot of people who think they are custodians of Indian culture, and marriage is a part of religion, culture, society, and not just individual choices. Are the courts treading on thin ice as far as these issues pertaining to marriages go?
Right. Look, you're right when you point out that this has, raised the hackles of many other people who believe that marriage is a so-called sacrament, or they believe that marriage is, or they believe that culture trumps the constitution. Okay, so in my opinion, this is a very, very fundamental issue. It's very important to establish that neither calling it a sacrament nor calling it culture can defeat the right of equality of partners to a marriage. It is the constitution which will have to take precedence over religion. It'll have to take precedence over culture. Okay. Now, this does not mean that two people can't marry in accordance with the rituals of the culture to which they belong. But those are rituals. The rituals do not tell you what is the substance of the marriage. I've said it very often. The law tells you how to enter a marriage, it tells you how to exit a marriage, but it doesn't tell you what a marriage is. And I think the courts are struggling with this issue. At the end of the day, what is a marriage all about? And my answer is, it's about equality. It's about love. It's about caring. It's about sharing.
You know, just one last point, ma'am, and it's an overview of how the Supreme Court is right now determining the law in many, many cases, something which the executive is supposed to do. And let's go back to same-sex marriage, where the argument has been that this is the purview of Parliament, not of the courts. Is that tension between judiciary and executive glaring right now, or is the court stepping over the line?
I think that's not the case. I think this is happening more because Parliament is almost becoming dysfunctional. We've had so many complaints that they hardly meet, etc., etc. But also because, there is an underlying ideology to the ruling party's approach to issues of every issue is a social issue. What's the point of telling us it's a social issue? Name one issue which is not a social issue. Today is May Day. Today is Labor Day. Do you think labor is not a social issue? And yet we do enact legislation, don't we? We say we have an 8-hour working day. Why? Oh, it's a social issue. Leave it to the society to decide. Or do we say that, no, leave it to the employers to decide? No. So the issue is not legislature versus judiciary. The issue is a certain ideology which is fighting for supremacy over the Constitution of India.
Absolutely. Thank you so much, Indira Jaisingh, for speaking with us. We couldn't have gotten a better expert voice today on this issue. So thanks once again for your time on Beyond the Headline. Now, more news from the courts. The centre today informed the top court that it's working towards re-examining the sedition law, and consultation with various stakeholders are at an advanced stage. The Attorney General representing the central government told the Supreme Court that issues may be discussed in Parliament during the monsoon session. After taking into consideration the arguments by the centre, the top court adjourned the plea and posted it for hearing in the second week of August. This batch of pleas in the top court is challenging the constitutional validity of the penal provisions of sedition.
Yes, in fact, the Supreme Court was hearing a batch of petitions which had sought the scrapping of the sedition law, that is 124A. Remember, on the last date of hearing, that is May 11th, the Supreme Court had asked the Supreme Court, the Centre had in fact requested Supreme Court to not to adjudicate further on this PILs, saying that it itself is examining the law and therefore the Supreme Court should stay the proceedings and awaiting the the Centre's decision. The then Chief Justice N.V. Ramana had in fact stayed all proceedings across the country under the sedition law and directed all authorities, including state police and centre, not to lodge any fresh sedition laws and allowed all the accused in present existing cases to apply for bail.